Welcome to Lawxpertsmv India. Hope I'm audible. If I'm not audible, feel free to stop me. And if you have
Need
any
to
doubt,
follow. Excuse me, yeah. If you have any doubts as well, please do ask me. Okay. So now we are first I would like to say we are having small numbers in each batch because we can concentrate on you. Okay. So whatever performance doubts you have and whatever it may be any doubt, how much marks you need to get to clear UPSC law optional in the mock test, like that. If you have any doubts, feel free to ask. So today we will be starting with torts. Many will feel that torts is not at all a subject. Torts is very easy. Yes, you are right. Torts is the easiest subject when we talk about UPSC law optional. But you have to remember, don't take it lightly because it is a subject where we can concentrate less. That is, we can spend less time, but we can score more. Okay, it is not like constitutional law or international law where you have to read a lot of topics, lot of areas. These are the basics of laws, but if you do it properly, then you can get good marks. Okay, if we are going to push that to the end, not being prepared, that will be a flaw in your examination because who's going to sit near you in the mains is equally equipped as you. So from talks, if basic question is asked, you'll be facing two difficulties. First, everyone will be writing almost same answer. Now, how you're going to impress the evaluator and get more marks? That you have to think about. Then, since we think that is it is the easiest one, we will push at the end. We will think that we will do at the end. We will just revise at the end will be very difficult because we will not have time to revise it. So whatever stored in your memory, you try to put everything what you know, and you will fail to satisfy the demand of the question. So don't push thoughts. It is the easiest area. You can just revise that in a day or two, get good marks. Okay. So we are starting with the easiest subjects, which is very, very easy, but you have to concentrate here. So I recommend you to listen to the class. First thing, when we are listening to the class, it is not that you have to take the notes because we have provided you with the PDF. So just listen to the class. Try to get all the concepts right. It will be your first idea. And after class, just take half an hour or 15 minutes to revise all the topics that we have discussed now. Tomorrow we don't have class because we do classes only on alternative days. Okay. So tomorrow you have to revise all the previous years that has happened in this particular topic. Okay. We are providing the previous year as well, the solved copies. So go through that and then take the answer writing practice. For every topic, we have 5 questions that is asked in your answer writing practice. So tomorrow you're taking the test. Today, take the class, understand the concept. If you want, you can make your own notes. I suggest you to take the own notes because at the end of the day, it is your notes that will help you revise better. Okay, but there are certain people who will revise from the PDF itself. If you are of that type, then you can go with PDF. Okay, so after the notes, take the previous year solved, finish it off, do the answer writing practice, and be exam ready. That is the total idea of UPSC live classes. Okay, so we will go ahead. One sec. All right. Yeah, I think the screen and the PPT is visible. If it is not visible, please do. Now, starting with the basics. What actually is a tort? Tort is derived from a Latin word which means tortum. You all know the basic tortum. What tortum means? It is twisted behavior. See, as a society, we all live in a society. Homo sapiens are, we say, we are social animals. Man is a social animal. It means we cannot live alone. But nowadays, we will be happy living alone in a single room if a cell phone is given to us. But in reality, even in cell phone, we will be looking about other people, right? So man is a social animal. So in a society, everybody is expected to behave in a particular manner. Okay. So if you don't behave in that particular manner, you do twisted behavior, then you are committing a, that is the basic idea of, okay. Now let me tell you, we have a lot of social norms. That is, if you are a woman, you get married at this particular age. If you are a man, you get married at 31, 32, and you have to work very hard, whether you like the job or not. You have to fetch a lot of money and give it to the family. And she will take care of the family as well. If she goes to the work, both of you go to work, take care of the family, have a child. This is what majority of the society thinks. Today, many people ditch this norm. Wait, what they do? Women, they don't get married. If they are married, they don't get the child. They say that we both are happy together. Why we need a child? Okay, these things are coming. Whether they are all committing tort, they are deviating from the social behavior, right? Whether they are committing tort. Again, let me tell you, if you discuss, our class will be very entertaining and we can study happily, right? So it's all about discussion. Anyone like to answer? Whether they are committing tort? Understood the question? Okay. Nobody understood the question.
No, ma'am, they are not committing the fraud.
Okay. We say that tort is a twisted behavior from the society, right? They are not behaving as per the society norms. And you say it is not tort. Why? Can I know the reason, please?
Because no harm is committed to anyone.
Very good. So the deviation is not from the social norms, not from the economic norms, not from the normal norms, but it is a deviation which is going to violate the right of others. Okay, me not bearing a child, I'm not getting married, I'm not working, it's not violating anybody else's right. So that violation of right is the key for this twisted behavior. Okay. So tort is derived from the word tort, which means twisted behavior. We are clear here. Now, the tort word, we had a similar word even in Sanskrit, which is called as jimha, which means a fraudulent conduct, which is not a normal behavior. Okay. So they say tort in England and we say jimha in Sanskrit. That is the basic difference. Now let's go ahead. Whatever I have told now, I'm culling out the keywords. So everyone is expected to behave in a particular way, but you deviate that is called as thoughts, and these thoughts are uncodified legal rules. So if you say law of crimes, we have IPC and the daughter of IPC, which is DNS, we have CRPC, and BNW is Indian Evidence Act, common for both civil and criminal law, constitution, all are codified. If you ask for torts, it is totally uncodified legal principles. Now, when there is no statute, from where it develops from the precedents, judicial precedents. So we call tort as judge made law. Okay, all these points that I have given you will be useful for introduction or conclusion. You may ask me for any answer, introduction and conclusion, whether I have to give weightage. Of course, you have. If you are giving a sparky introduction, definitely you're going to get a good mix. Okay, now, what's purpose of this thought? They say, what is the basis of this thought? Comes from this maxim, ubi jus ibi remedium. This maxim is very, 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 very important. I said, don't take thoughts as a light subject. That too, first topic of thoughts is where most of the question is asked in your UPSC law optional means. Every topic you take, the first topic is the most important one. Okay. In 2025 means, recent means also, we got a question only from this maxim. So let's read the maxim. Ubi just ibi remedium, which means any right transgressed, there must be a way to compensate or restore it. So if you are having any right, and I'm doing a twisted behavior that is violating your right, then what happens? It should be compensated. It should be restored. That is the complete idea of torts. Okay. So where there is a right, there is a remedy. So what is the remedy that tort is talking about? is compensation. If we talk about criminal laws, what is the remedy that criminal laws are talking about? You violate IPC, BNS, what is the remedy we will be provided with?
Punishment, ma'am.
Punishments, imprisonments, fines, which is not compensation. So, in torts, the remedy that we are talking about is compensation. You have to be very clear about that. Now, let me tell you how right is violated. Basics. Okay. So you explained what is the maxim and then you give some examples. So always how to enhance your answer, you give a good introduction and give the prop cons. If it is a statute, try to give the statute number, that is a section number, ingredients, and support your concept with some example or case law. So coming to the example, in defamation, you have a right to stay dignified. Right? Harming your reputation is violating your right. So your right is violated, there will be a remedy. That's why defamation is a top. Okay. Next, trespass. You have a right to protect your property. You have a right to enjoy your property without others' disturbance. That is your right. If you are violating that right, then it is a tort. So unauthorized entry will be the violation and it will be punished with compensation. Okay. Next, talking about nuisance, you have a right to stay peaceful. If somebody is disturbing you, causing annoyance, then that is a twisted behavior. Your right is violated and compensation will be given. Okay, so like this, you can spot some examples. Now, let me give you another question. I have built my concept as well as that is based on the previous year question because everybody say UPSC law optional syllabus is vast. I do agree with that, but only if you can focus the syllabus from the previous year questions, you can make much out of it. You can, because see, reading law optional is not hard, but doing the optional along with your GS and prelims is very hard. That's why we are narrowing the subject down to the previous year questions. We finish each topic in 2 hours and you can spend other time with your prelims and GS, which is very, very important. Okay. Now, coming to another question. In tort, the plaintiff wins his case only when he proves as to what a tort defendant has committed against him. Examine. So, in the field of torts, it is required that the plaintiff must prove that the defendant has done a type of tort. So, he has done defamation, he has done trespass, or he has done negligent. So, any or his action must fall on particular type of tort. This must be proved. Only then punishment can be given. That is the demand of the question. We can think like from where they got this statement. It is nothing but the theories of thought. So if you talk about theories of thought, we have two types of theories. First one is the general theory. We call it as the growing theory. It is like a tree, okay? Growing tree theory. But the second type is called as a pigeonhole theory. Let me explain both the theories and you're going to find out which theory we are asking in this particular question. Okay, so let's go ahead. So the first theory, general theory says that law of torts means, that is tort means a wrong done by someone. So tort means a wrong committed. We recognize all the general torts. So basic thinker of this theory is Winfield and Pollock. And what they are telling, all injuries done by a person will be tort unless a lawful justification is given. So I do some injury, I commit any injury without lawful justification, then that becomes tort. So it need not have any name, anything, nothing is required. Only I have to prove what there is one injury and I have done that injury without any lawful justification. It's totally enough. So that is the basic idea of general theory of. So what they say, any unjustified harm is taught. Now, let me make myself clear. If any question comes from a particular legal concept relating to a section, it will be very easy for you because section, ingredients, case law, finish over. But when any question comes on theories, principles, definitely writing a proper answer will be challenging because you'll know only 4 to 3 lines and you have to project it in a proper way. So, for theories, I would definitely advise you to break it down as side headings and then try to structure your answer well in a unique way so you put your ideas clearly. Okay, you will not repeat the same thing again and again. That will be stopped. Okay, now going to the theory. So, the general theory says that all injury is done that is without any legal justification. Then it is a okay, that is the idea. So, unjustified harm is projected as a what is the advantage of this theory? This theory's scope is very, very wide. It does not say that you have to give a particular name. It does not expect anything from you. Even in today's world, this theory will be good. So they may not, in earlier days, they may not have thought about online scamming and what about credit card skimming, data theft, and all those things, right? So criminal law rests on torts. Torts is the basic from where we branch out with criminal laws. So this theory is very wide. You cause an injury without any lawful justification, that is totally enough. So it can be an assault, it can be a battery, it can be a slander, negligence, even an action with no name can be a tort and it can be punished. Okay. And it allows scope for growth. So whatever new concept of violation of a right comes in, can accommodate. The theory is like that. It is very wide. That's why we call it as a growing tree theory. Now you may think why she is calling this theory as wide. We can't understand. You will understand once we pitch to the next theory. Let me talk about the next theory as well. Pigeonhole theory. As the name goes, imagine pigeonholes. Then it will be very easy for you. You know, the pigeon will be kept in small, 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 small holes like this. Okay, I think you would have seen it. I have seen it. My neighbor had a pigeon and pigeon, a lot of birds. So I have seen him having small, 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 small holes where pigeons go and get inside. Each couple will go inside one hole. Okay, like that. So pigeonhole theory was advocated by Salmon and Glanville Williams. Okay, so what is the premise they told? A recognized number of torts are there. So there are particular number of torts. And if it goes outside this, then there is no liability, which means there are particular number of named torts like defamation, assault, battery, negligence, trespass. We name the torts. There are definite numbers. If the action of the defendant falls under any of the torts, then you can punish. But if the action does not fall under any of the torts, then you cannot punish him. Just like IPC. If any facts comes in, if you are an advocate, you would know. We do have non-law students as well. If an advocate, you would know. Clients will come with a fact. Immediately the advocate will think, this action falls under which IPC section, right? If it falls under IPC sections or BNS sections, it is a crime. If it is not, we cannot complain it, right? Like that, the pigeonhole theory says that there are recognized number of torts. So if your action falls outside this, there is no liability. Okay, that is the idea. So what is the rationale they are telling? When you don't know the offense itself, when the offense itself is not recognized, then how to punish it? That is the question. You generally say there is one right and the right is violated without any justification. You give the penalty. But it's not right. If you're not able to name the offense, if you're not able to name the torts, then how we can punish the person? That is the rationale that they are bringing in. Okay. So the theory says tort law consists of pigeonholes, a set of pigeonholes. and each containing a specific tort like assault, battery, negligence. So the defendant action must fit into any of these holes. If it does not fit, then there is no tort at all. So you see, when we compare to the growing tree theory, the pigeonhole theory has a very limited scope. Only when if it falls under all these heads, it is taught. If it does not fall, then it's not taught at all. So it has very fixed, limited scope. And the scope is completely static. So if a new offense comes in, say example, in BNS, we had a new offense which is called as snatching, which was not an IPC. Okay. So the new offense came in, we had to change the law and then only the offense can be punished. But in pigeonhole theory, already they have prefixed all the torts. Now, how do you change it? There is no scope for improvement at all in pigeonhole theory. Limited in scope, it is static, no scope for improvement. Okay. And there are huge chances of injustice merely because your action does not fit inside any dot, merely because that we are not able to see. It is the incapacity for us to foresee certain wrongdoings. Let me tell you one classic example. If we talk about cohabiting, that is having sexual intercourse in the false promise of marriage. So there is a couple, husband, no husband and wife, girlfriend and boyfriend. Now boyfriend cohabit with the girlfriend with a false promise of marriage. Okay, he can be punished. We have a provision under IPC as well as BNS. If a girl does the same thing, we cannot say that girl will not do. I'm not against girls as well. I'm just talking law. So you reverse the role. The girl is having a sexual intercourse in the name of false promise of marrying that particular person. Because heart is same for both people, right? If it is broken, both will ache. So she's doing that. Whether that is punishable under IPC or BNS? Any idea? You can say no or yes. Just take a wild guess. No idea. We cannot punish the girl. We
No, ma'am.
advocate. Yeah, we
Mm,
cannot punish Mr.
mm.
Karthik. You are right. You see, we talk, we are equal. Women are like, see, we are independent, but we cannot be punished for this. But the other side, the men can be punished. So just because it is not called as an offense, we are left out. This is injustice, right? That's what is happening here. Just because we are not able to foresee a new type of thought or we are not able to name it, the person who is doing injustice will be left out if we follow this type of theory, pigeonhole theory. You understand? So these are the disadvantages. So how do you write the answer for theories? First, you give a good introduction, and then who's the thinker, and what is the premise or basis of it? What is the advantage? What is the disadvantage? Okay, and you try to give examples to support your theory. That is very, very important. Now, someone help me read this question and tell me which theory they are asking.
Can I, ma'am?
Yes, yes, please.
In tort, the plaintiff wins his case only when he proves as to what particular tort defendant has committed against him. Examine. That will be the pigeonhole theory, the second theory.
Excellent. Yeah, good. It is simple as that. So if you do the introduction and do all these, give all the premises, your answer will be loaded. Okay. Now going ahead with the second question. I'm not going with the question numbers. I'm going with the concept, but matching with the questions that have been asked in previous year. Okay. So law of torts is based on a fundamental general principle that it is a wrongful to cause harm to other persons in the absence of some specific ground of justification of excuse. Examine. What is this? What they are asking? You heard wrongfully cause harm to other persons in the absence of some specific ground of justification. What happened? Not able to get what they're asking? Okay, take time to read it. Who wants to read it? Someone take time to read it. Nobody wants to read. Soumya is there. Soumya wants to read. Or Karthik can try. Karthik, would you like to read? Yeah, please read. Yeah.
Both
Hmm.
upon a fundamental general principle
Law of tort
that
is
it is
based upon, yeah.
based upon a fundamental general principle that it is essential to person in the absence of some specific ground of justification.
Or excuse.
Yes.
It has to be
General
theory.
theory.
Because, oh yeah, what is the premise of the general theory? It is all injuries done by a person is taught if there is no lawful justification. So you're talking about the general theory. It is simple as that. So every aspirant must have this, even for GS. Immediately read the question. You have to understand the demand of the question. That's where you stand apart from others. So how do you, because see, you read the question and you wait for 10 to 15 minutes to understand the demand of the question. Don't do that. Within 2 minutes, 2 minutes is also long. Within 1 minute, you have to immediately know the demand of the question. How that you can do it is you have to take all the previous year questions and do the previous year simulation. You read the question and immediately identify the demand of the question and write all the hints. In case you're not able to write the entire answer, at least do the hints part. This section, this ingredient, this case law. That's totally enough to train your brain to immediately find out the demand of the question. Okay, do that exercise every time, even for GS. Okay, now coming to the next thing. These thinkers are very lavish, giving a lot of definitions. Only we are here to struggle reading all this. But once you enjoy law, you will do better. Okay. So coming to Salman, it is a civil wrong. He says, tort is a civil wrong. This is a famous one. Tort is a civil wrong, but for which the remedy is common law action. So you want the remedy for the civil wrong, go for a common law action. What you will ask there? You ask for unliquidated damages. So tort is a civil wrong. The remedy for this civil wrong is there in the common law action. And what is the remedy that you will be seeking? You seek for unliquidated damages. Okay. Now, which is not exclusively the breach of contract or breach of trust or other mere equitable obligation. It may sound something like la 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 la, very, very huge, but it is very, very important definition. Because Salmon's definition is given as statement-based question in UPSC. Okay. So tort is a civil wrong, which means it has the entire characteristic of civil nature. See, for criminal action, who will initiate a case in criminal law? It is the state. Prosecution have to prove. But since we say tort is a civil wrong, who will start the case? It is the plaintiff. Individual have to initiate the case. Okay. Next we talk about the procedure. What is the standard of proof in criminal laws? It is standard of proof in criminal laws? Proving beyond reasonable doubt.
Reasonable.
Yeah, even a small doubt is there. The benefit of doubt will go to the accused. But that is not the case in civil areas. In civil wrong, imagine a balance. That is in Tamil, we say tarasa. It is a balance. Okay. Whichever side is giving the better evidence, that side will get the judgment. Preponderance of probabilities. So, tort is a civil wrong. The initiation will be done by the private individual. The standard of proof is very simple, which is preponderance of probabilities. And the punishment, you cannot expect imprisonment. In civil wrong, the punishment will be compensation. You can ask me about civil prisons, but civil prisons is a different area where you will pay for that person to stay in the prison. That is even more very, very hard. Okay. So civil prison, don't take that into mind. Civil wrong, the main area of remedy would be a compensation. Okay. So tort is a civil wrong means all these things. Now coming to the remedy. They say remedy is unliquidated damages. What do you mean by unliquidated damages? In a contract, there'll be terms. If you violate these terms of contract, you have to pay 1 lakh, 2 lakh. So the remedy can be quantified damages. But if you take for torts, you commit some defamation against me. Whether I will have a settlement with you, like earlier itself. See, I foresee that you are going to do some defamation. So for my reputation, I put a tag on my reputation saying that you have to pay 5 lakh rupees, 3 lakh rupees. Already, whether it is quantified. No, in torts, the damages cannot be prefixed, cannot be quantified. That's why we call it as a unliquidated damages, and which is not exclusively breach of a contract, breach of trust, or equitable obligations. So the author is very intelligent. Civil wrong, yes, tort is a civil wrong, but there are other kinds of civil wrong as well. Contract. If you breach a contract, it's a civil wrong. If you commit breach of trust, it is not criminal breach of trust. You have to see it is breach of trust. That is as well a civil wrong. So tort is a civil wrong, but we have other areas of civil wrong as well, and that will not be included in this. That is the basic idea. Let me break up all these points to you. So tort is a civil wrong. You have to talk about the initiation, procedure, evidence, punishment, what all difference. And then you talk about the remedy, which is unliquidated damages, means not predetermined damages. Next, not breach of contract or breach of trust. So let me come to this area. You see, a civil wrong is the wider area. Now, tort is one part of the civil wrong. Okay, what are the other civil wrong? We have breach of contract, breach of trust, and whether breach of contract is a tort? No, it is not so. So, tort, all torts are civil wrong, but all civil wrongs are not. We got the statement right. All torts, if you see, it is inside the box of civil wrong. But all other civil wrongs, you see, whether they are coming under the tort, they are separate. So this statement is repeatedly asked as a question. So all torts are civil injuries, but all civil injuries are not torts. Okay, you have to explain the statement. Let's see how to explain at the later point of time. Now, any theory they are asking, you never skip the advantage and disadvantage of this theory. Okay, so we have Salmon giving all the important points. It is a civil wrong, it calls for common law action, and the remedy is unliquidated damages, and it is not exclusively breach of contract, breach of trust, equitable obligation, all he's telling. Okay, still there'll be someone telling that your definition is wrong. That's what is criticism. We'll be studying from morning to evening at home in a particular area in our desk, and some aunt will come and say that, see, look at your son, always looking at this laptop, what he is going to do. Ask him to come out and he can enjoy the Dasara, right? We'll hear that. So, like that, so there is always a criticism. Don't forget the criticism. That's why we got this story. Okay. So, many say it is an incomplete definition. Why it is incomplete? Because Salmon did not say what is a civil wrong. He did not define what is civil wrong, it seems. So when you're writing the answer, don't just mention that it is incomplete definition. You have to say why it is incomplete. Okay, civil wrong, not defined. And the tort contain criminal offense too. Can you say any criminal offenses that converge with torts?
Trespassing.
Yes, exactly. Trespass, defamation, assault. Assault in torts is criminal force in your IPC. Okay. So they say it is a criminal wrong which is given a civil remedy. So you cannot call it as a civil wrong. That is one side of argument. When they say, you do not say when a civil wrong arises. You say civil wrong. You don't define what is civil wrong. And you don't even say when a civil wrong will arise. Okay, so it is an incomplete definition. Then you talk about remedies for torts, We have other remedies as well. What is the remedy he told? Unliquidated damages, which is basically a compensation. So we have other remedies like self-help, like injunction, mentioned here. So it is completely an incomplete definition. That is their criticism. Okay, you write the criticism. And when we come to all civil injuries, all torts are civil injuries, but not vice versa. That statement, you have to differentiate between other civil injuries. That is, contract, you differentiate. And let me differentiate and then come back to the next thinker so that it will be helpful for you. So we have to differentiate like this. Then only you can justify the statement. Okay. So first, when you talk about torts, what is the concept of torts? It is a deviation. Deviation from normal behavior. Okay. What is the concept of breach of contract? It is also a deviation, but this deviation is from the terms and conditions of the contract. Okay, it is not from the normal behavior, what society thinks. Contract is not worrying about that. It is worried only about the terms and conditions of the contract. So the deviation is from the terms and conditions of the contract. Next, when we talk about the nature of torts, it is a violation of right, but it is a right in rem. Rem means a right which is which is owned by everyone. We have a duty towards everyone. So right in rem and duty in rem is involved in torts, means duty towards everyone. Say for example, I have a duty towards everyone that I don't be negligent and harm others. And also I have a duty, I don't violate others' peace. Say for example, I live in a flat and I at 12 o'clock I burst out my pressure with with a very loud music. Now what it happens? Everybody have a right in them to stay peaceful, and I owe a duty towards everyone not to disturb them. So when I do this, it is a violation of right in them, violation of my duty in them. But when you come to breach of contract, there is violation of right, but this right is personam. It belongs to that particular person, personal right. Whether I put a contract to the entire world, no, that particular party, I own a right. And I violate that right in personam, the duty in personam, then only breach of contracts comes in. Okay, it is against a third part. That is, it is applied only to the parties in the contract. But against third party, I don't have any right or duty. Okay, that is another difference. Next, when tort comes, we say a duty. Who fixes this duty? You shall not be negligent. You owe a duty and care, and you shall not disturb others. You shall not defame others. And all this duty, who fixed this? It is a duty fixed by law. But when you come to a contract, the duties are fixed by the terms of contract. The parties fix the duties. Okay, so that is another difference. Then coming to a remedy, in torts, we told what type of remedy we are looking for. In torts, what Salman told?
Unliquidated damages.
Unliquidated damages. Very good. Okay. So in Bim Singh was a state of, so you support all these points with the case law. It is very good. I have come up with 4 to 5 case laws. We do case law pooling, which means you study a fixed number of case laws and use the case laws in different areas. That's how we can escape law. Because if you keep on studying a lot of case laws, we are not having pressure cookers, right? So that cannot be done. Try to use a single case law in 2 to 3 areas so that you save time and energy. Now, coming with Beam Singh was a state of JK, it says that plaintiff was given exemplary damages for violation of Article 21. Actually, he will be kept in prison for more days than what he deserves. Okay, even after he is acquitted, he will be kept in prison. So for that violation, he will be paid money. Okay, that you can give. I have other interesting case laws also. You can quote. Now, coming here, there are various remedies available in breach of contract. We do have specific performance act for contract. Compensation is there. Restitution is there. So the remedies are more here. And we have one more remedy, compensation, talking about it is maximum liquidated compensation. We can talk about liquidated damages in contract, but there is no concept of liquidated damages in torts. What is the reason? The tort damages is unliquidated because it is which the damage. How much they will damage, we don't know. So that's why we have unliquidated damages. You give that one. We come to contracts. Basically, most of the matured contracts, that too in modern day contracts, they have a clause which predetermine and stipulates penalty clause. Okay. So in contracts, predetermined damages are usual. That can be done. Okay, you mentioned that. Next, you talk about torts. It is committed when a legal right is violated. But when to contract, a contractual right is violated. What about the relationship of the party? Whether the tortfeasor and the victim will have any relationship? Absolutely no. Okay, they don't have any particular, they are not related at all. When we talk about a contract, the offender and the victim are in contractual relationship. Okay, so you may think the points are very extensive, but in order to score mark in differentiation, at least you have to think in 360-degree, bring about all the small things. If you are able to put a tabular column and bring out the differences, you're going to get more marks. Okay, so this is the difference between torts and breach of contract. Now coming to the difference between tort and a crime. You give me one difference. Each one try to give one difference. What is the difference, basic difference between a tort and a crime?
The prosecution would be initiated by the state in crime.
Okay, good.
Tort is a personal grievance.
Very good. So you have given the fourth point, the initiation of the proceedings. Tort is called as a civil wrong. So since it is a civil wrong, the private individual have to sue for damages. Okay. It is a criminal wrong. State will take everything in hands, and the initiation of proceedings, it is a public wrong. So the suit is, we can't call it as a suit. The case will be filed by the government, or the proceedings will be taken ahead by the government. Okay, that you have to say. Any more points from others? Because listening to a single person is very hard, because I was there in your position where I used to listen to a lot of lectures. We'll sleep off. So why don't we interact?
I mean,
Any other
crimes,
point?
it will be imprisonment.
Talking about punishment. So the remedy for torts is unliquidated damages. We can ask for injunction, self-help, everything is available. But the remedy, the punishment in the criminal area is fine. It is not compensation. Fine unless and until mentioned by the statute, except in rape cases and causing hurt by acid attack and all those things. Other fine go to the treasury. Okay, it goes to the government, not the victim. And compensation only developed in recent trends in crimes. But what is the solid punishment? Imprisonment, even capital punishment given in crimes. Okay, you have to mention all this. Okay, any more points? Anyone else? No. So sad. Okay, we will go ahead. Start with the concept. Okay, so what actually is a tort? It is a deviation from the normal behavior. It is relatively less serious than crime. Yes, crime is also a deviation, but it involves a serious deviation like murder, rape, and kidnap. Okay, tort is something very small deviation, and crime is like something going in the opposite direction, very serious. Okay, next we talk about the nature. Although it arises from the violation of right in rem, that is a public duty towards others, right in rem is violated, it is an offense against individual. It is a private wrong. But this violation is, that is a crime violation is right in rem, but it is very serious. So we consider it as offense against the society because of its grievous nature. We call it as a public wrong. Okay, you have to talk about the concept, seriousness of a deviation, Because it is serious, what we say, we call it as a public wrong. Although it is also a deviation, it is not so serious, we call it as a private wrong. So that difference you have to bring in. Then, talking about intention, whether intention is relevant under torts, talking about negligence also, intention is relevant?
No, ma'am.
No.
Intention
No.
is not.
Yeah, if the damage is there, if the right is violated, that is enough. Irrelevant. Intention is irrelevant. Wrongful act violating your legal right only matters. But when we come to crimes, I'm talking about the general rule, there should be mens rea. Mens rea and actus reus together coexist, then only crime is committed. Okay, so intention is the first stage of the crime which should be established for the criminal liability. Crime cannot happen without mens rea. That is the basic general rule. We have statutory offenses, but in differentiation, we talk about only general rule. Okay, that you get. Initiation of proceedings remedy is over. Finally, civil form of justice, entire nature is different, which we talk about. The standard of proof is preponderance of probability. You can prove lesser. Proof standard is lesser. But when we talk about criminal justice, the standard of proof is very high, which should be beyond reasonable doubts. All these points you have to get. Now, jumping back to one sec, other definitions. Okay, I believe you don't need a break as of now. We will finish two more definitions and go for a 10 minutes break. Okay, coming to Winfield. After Salmond, we have Winfield, which is again an important definition. I think I have done earlier slides. Okay, yeah, yes, we have done it. Coming to Winfield, what he says, tortious liability arises from the breach of duty. You see earlier, Salmon told tort is a civil wrong. He did not say how a civil wrong comes, when it happens. But see, Winfield is trying to compensate it here. Tortious liability arises from a breach of duty, which is primarily fixed by law. Such duty is towards persons generally, and its breach is redressable by an action for unliquidated damages. So you see the stage, he talks about tortious liability. When it arises, you do some breach of duty. Now, what type of duty it is? It is a duty which is fixed by law. That answer he is giving. And this duty is towards everyone generally. So if it is breached, you have a remedy by an action for unliquidated damages. That's what he says. Okay. So the criticism of Salmond is that Salmond did not say when a civil wrong arises. That is done well. That is corrected by Winfield here. Winfield is giving it when the tortious liability arises. It arises when there is a breach of duty. And this breach of duty is prefixed by the law. So you have a duty against every general public. And once this duty is breached, where is the remedy? You go seek remedy for unliquidated damages. That is the 3 point that you have to mention. So these definitions, if you are able to verbatim give that in your answer, it is very good. If you're not able to give verbatim, you can choose the ingredients, what I have told now, right? Those are the ingredients. So you mentioned that in 3 lines, that's totally enough. Now, going to the nature of duty, what he is telling, it is towards persons generally. So it is distinguished from a contract. You know how it is distinguished. Just now we told that. So the duty is primarily fixed by law and not the parties. Individuals cannot create tortious liability. Although tort is a civil wrong, tort is a private wrong. That is, tort is an individual concerned wrong. Individual cannot create a tortious liability. I cannot put an agreement with you to create a new type of torts. Okay, that cannot be done. Now, as an individual cannot create such a tortious liability, he cannot negate that liability too. How to understand this? Say, for example, I am having a very big hospital and I am treating all the patients. I have very good doctors and I have very good equipped machinery more than the state. Usually, we don't prefer state hospitals. Let's be frank. Okay, those services In Tamil Nadu, it's not so up to mark. Okay. Third time, I have a very big hospital, very good doctors, but every patient comes in, I'll ask them to sign. We say that I provide you good services. But in case, if any of my doctors treat you negligently, you will not file a case against me. So what I'm trying to do here, imagine there is no criminal law. So there is only torts. So I'm asking the individual to negate his right of this to claim a suit based on torts. Okay, tort is not created by an individual. So the individual cannot negate the tort as well. Okay, it goes like this. You don't create it, so you cannot negate it. So can I bring a form like that? That is not tenable even in today's law, because any agreement in like in precluding you from legal action is in contract is what? An agreement stopping you from legal remedy is void. Okay, we have that in contracts. So that goes with the modern world. But when you're talking about only tortious liability, tort is not created by the individual, so it cannot be negated by the individual as well. This is another point. I gave you an example with the doctor. You can quote that example in examination. And the remedy, what he does is unliquidated damages. All these thinkers agree with one thing. What is the remedy of tort? It is unliquidated damages. Okay, so you have to remember that. Now, what is the criticism? They say that you fail to distinguish with other branches of law. What Salmon did, it is not breach of trust. It is not breach of contract. He distinguished, right? That line is missing in Minfields, it seems. Okay, so he did not distinguish between other branches of law. And they say it is a vague definition. So, towards persons generally, what do you mean by that? And here also, you do not talk about other remedies, which is self help and injunction. And why don't you talk about that? So, one thing is clear, however excellent you do, there will be some people who will be criticizing you. So, if there is a theory, don't forget to criticize. Okay, so these are the criticisms, and these are the related UPSC questions. You can read it after the class. You can exactly write what I have explained over there. Now, coming to Sir Frederick Pollack, his definition is not asked usually. He has given a very big definition, which is not precise as well. So, just read it after the class. If any question talks about the definition of torts, I recommend you to write the first two definitions, Salmon's one and the next one. And you can supplement it with the definition given in our Limitation Act. It is similar to Salmon's. It says that a tort means a civil wrong, which is not exclusively a breach of contract or breach of trust. Okay, so if you give the definition of two people and the Limitation Act, it is totally enough. So these are all like phases and all. If you have to, you can quote. Okay, now going ahead to two important principles of tort, which is injuria sine daminum and daminum sine injuria. Shall we go for a 5 minutes break and come back studying these principles? Because
Yeah.
it will be difficult for you to listen, right? So we'll go for a 5 minutes break. 6:05, I'll come back and we will do these principles. Thank
Okay.
you. Yeah.
Okay. Yes.
Let you promote. Apologies for extended break, but I promise to finish the subject on time. Okay. Let's go for these two important principles. Mostly UPSC is focusing on these two principles, which is the core of your thoughts. Okay. So first maxim is injuria sine damino, which means there will be injury to your legal right, but there not be any monetary loss. Okay. There is injury. That injury comes from the violation of your legal right, but there will not be any monetary loss to you. Okay, many we will think that tort is always concentrating on the damages. How much monetary loss is that? So we, because in torts What is the remedy? It is unliquidated damages. That is a compensation. How do you determine the compensation? You talk about the damages that happen, how much loss has happened, how much monetary loss is there, and then you give the compensation. So what is our idea? If there is any monetary loss, then only torts can be invoked. But on the contrary, there will be injury. There will be violation of your legal right. But there will not be any monetary loss. Let me give you an example. In this case law, Ashby versus White, very important landmark case law. In torts, never forget to write the case law because we don't have any statute. So in torts, you have to write the case law. Okay, so there is a person, she will not be allowed to cast her vote. So election is going on, she will not be allowed to enter the ballot. Okay, so is there any monetary loss for her? No monetary loss at all, but there is violation of a right to vote. So it is a classic case where is an injury which is violating a right to vote. There is no monetary loss. The court told monetary loss is not important for torts. If the right is violated, there is an injury, EB right? Yeah, sorry, UB remedium, right? So when there is a right is violated, UB just UB remedium. Totally enough. Then we will give you the compensation. So you have to write this and then you have to quote whenever there is a legal right violated, regardless of the monetary terms, it is actionable. And you support it with this case law as well as Bing Singh case law. Here an MLA will not be, already we saw, right? MLA will not be allowed to attend a proceeding in the legislature. Okay, so he is stopped from attending the parliament or some legislature. That's it. Okay, member of legislative assembly he is. So he'll be going to the legislature like that. You can compare it with the parliament as well. But remember, he is an MLA. Okay, don't put it otherwise. So member of legislative assembly is not allowed to attend the state legislature. So whether there is any monetary loss, there is no much monetary loss, but his legal right to attend the proceedings is violated here. For that, it is becomes a actionable. Okay, these two case laws you have to give. If you're able to give one more case law, also it is good. At the end, I'll let you know how many case laws you have to quote for each answer at the end. Now, coming to the opposite principle, which is daminum sine injuria, which means there is only monetary loss, but the legal right is not violated. So how this happens? Say for example, in this case law, Gloucester versus Grammar School, which is very, very landmark case law, there will be a school and a rival will start a school just opposite to it. So there is some competition. Say for example, you open even a small bread shop and the opposite, there is another bread shop and a cake shop. What happens? Your customer will be divided. You will have a lot of monetary loss. Right. So there is loss when there is any violation of your legal right. It is that only you have to do the business. Others shall not do. There is no violation of the legal right, but there is only monetary loss. How torts see this? Whether it is an actionable tort? No. Simply monetary terms cannot be ground for taking action against the defendant unless and until there is violation of the legal right. That you have to quote. In one more case law, Mayor of Bradford versus Pickles, what happens here? There will be adjacent land. Okay, say for example, there is this land and another land. So I am having a small well here and my neighbor is having a very deep well. So what happens? I will not be having much water. All the water will go to him. Right. So whether he is violating any of my legal right, no. In his land, he is having his own well. So there is violation of any legal right. But I suffer a lot of monetary loss. Now I cannot take this as an actionable claim. What I have to do, I have to deepen my well. That's all I can do. So again, I would tell you, simply monetary terms cannot be a ground for taking action against the defendant unless and until there is a violation of your legal right. So these are the two principles. Now you can ask me a question. We have read about torts so much, whether it is useful in today's scenario. Because any tort question, if you are able to relate it with present day scenario in your conclusion, you're going to get good marks. So how do you relate it? Article 300 is there, which talks about tortious liability of the state. We have a separate heading, separate topic, and we will have a separate class for that. Just giving you a hint. So Article 300 you can quote, talking about tortious liability of the state. And Rudal Shah case, in that case, they have given 14 years unlawful confinement where he got a lot of compensation. Next, you have Bhim Singh case where he was not allowed to attend the assembly. These cases all happened after the constitution. Okay. And then you talk about absolute liability. MC Mehta was Union of India. Strict liability we have, which is tortious liability. And then you have tortious liability, which developed to absolute liability. So even the principles of torts, no doubt, it forms the basis for criminal law, and also it helps the environmental law, which is the burning topic of today's world. Okay, so you can talk about absolute liability, and in this 2005 case law, medical negligence is taken seriously. Yes, I know medical negligence is dealt under 304 capital A of IPC as well as 106 of BNS, but where it gets the root, this negligence topic is from the torts, so you can connect it. And then, yeah, negligence, how negligence is used. Even in 2023, this case law, they mentioned the tortious liability as well. Okay, so you can quote all these things for your conclusion. Any one, if you quote also, it will be good. So let's go ahead with the recent question. I'll solve the recent question for you. 1 second. Yeah, we do provide the previous year solved. You have a lots of questions which we saw earlier. Those things will be repeated. But I would request you to go through so that you get the reassurance. You have done the topic. If you are able to solve all the previous year question, it means you'll be able to solve the upcoming question as well. Okay, that's why. So this 2025 question, the law of torts is, yeah. Would you like to read? Yeah, please.
No, ma'am. Actually, I was about to ask, where can we find this file?
It is there in the app, and also we can send it to you. I'll ask the team to guide you regarding. Okay. Okay. So the law of torts is said to be a development of the maxim ubi just ubi remedium. Illustrate your answer with the help of decided case laws. It is for 15 marks. Okay. So your introduction can start from a general point. If it is for 10 marks, on the page limit that is given will be 1.5 side. So the question will take half of a side. So you have to prepare for two sides will be given. So half side will be the question printed. So what I suggest you to is prepare 10 marker for two sides or 1.5 side maximum, not more than that. But if you go for 15 marker, you will be given three sides. Okay, so you can start from what actually is a tort. Law of torts is a branch of civil law. They are asking ubi just ubi remedium. Okay, so you talk about what is a tort. It is a civil wrong. The remedy is unliquidated damages. It is a judicial development, which means it is not, it doesn't have any particular statute. So from where the judicial development comes from, it comes from the maxim ubi just ubi remedium. What is the meaning of the maxim? Where there is a right, there is a remedy. And then you talk about what is the cornerstone of torts. Because see, even against the private, that is, tort is a private wrong. Okay. And what are the remedies it provides is based upon the violation of the right alone. So I have put it in these words. This maxim signify the existence of a legal right necessary. So the cornerstone, the important point in tort is not the damages. It is the violation of the legal right that I am pinning out here. Okay. And then you give split out the maxim and try to give the answer like this. You can do a small diagram, but make sure your diagram is not so big that it consumes the space, because every centimeter in UPSC sheet is mix. So like that just means a law recognized, and remedium means which is the remedy that is given to the violation of that right that you have to give. And whenever the law confers a right, it must also that there is some remedy for its violation. That is the total idea of ubi just ubi remedium that you mention. You support it with case laws. Ashby versus White, I am not allowed to vote. My right is violated. Then there is a remedy. No need of monetary loss. Then you support. That's what I have See, I have given small side headings to explain the case laws. Why I have given is that mostly people will give the case laws and write what is held. That is okay for constitution sometimes. But if you're going to talk about torts, you have to give the facts, because how that principle is applied in that particular fact is the law, is the entire thing. Case law is very important. So one line you got, it is not that you have to write 4 to 5 lines. That applies even to the doctrines of your constitution. You talk about doctrine of repugnancy, doctrine of eclipse, doctrine of waiver. There is, yes, you can relate it to some article, but how that concept is applied, for that you have to give two-liner facts. So you tell the fact she is not allowed to vote. There is violation of the legal right, although there is no violation of the, although there is no monetary loss, and you give the small maxim. When you talk about Beam Singh, we just saw the case law. MLA not allowed to enter the legislative assembly. Okay. Next, you talk about the Gloucester. So every time you talk about the concept, give a positive case law and also give a negative case law. In Ashby versus White, they told there is violation. But in Gloucester Grammar School, what they told, there is no violation, only monetary loss. So remedy cannot be given. So ubi just ubi remedium. Where there is a right, then only remedy. But in Gloucester Grammar School, there is no right, so there is no remedy. Like that, you finish off and finally talk about the limitation of the maxim. You see any UPSC question, they will ask you to explain. They will ask you to critically examine. So you have to weigh those terms. It is very important. What do you mean by critically examine? It means you have to give the positives and also negatives and finally give the way forward. Okay, like that. What is the limitations of this maxim? This maxim, I mean, Torts does not talk about moral or social wrongs. Then it is like political wrongs and all, it doesn't come. Adequate remedy, say it is, it's not like a specific statutory remedy. If your remedy is in statute law, it is more grounded, right? That you can talk. And in the absence of legal injury, there is no, even though you have suffered some damages, there is no remedy. Okay, all these things, if you want, you can give it in the conclusion. Two things if you give, that is totally enough, and conclude your answer like this. Okay, any doubts here? Anything you want to ask? Understood the concepts?
Yes, ma'am.
Okay, thank you. At least one person is answering. Okay, Karthik understood. Shubham understood? Do you have any doubts? Any difficulty in following?
No, ma'am, no doubts.
All right. Okay. Anybody else? Any doubts? You can ask me. Okay. So what you have to do, if you want, you take separate notes. If you are okay with the slides, if you are able to quickly recap all the slides, then it is totally good. Go for the previous year question. I'll ask the team to send previous year question in your WhatsApp. So conveniently you go through, and tomorrow take the answer writing practice and do send it across so we can evaluate, because you say you understood. And how do we know that you understood and you are in the right track? Let me tell you, if you are able to score more than 110 in all the, say, all the tests, we are providing 25 tests, right? If you're able to get more than 110, then I can write and give you that you can clear UPSC option means. You see all the toppers in the website, they have given more than 15 tests and consistently they have scored more than 110. And Jaspinder Singh, who has secured AR 33, he was the one who wrote more than 25 tests because he subscribed to another test series as well. Okay, and he has scored more than 110 always. So please do take the test. Tell me, sir, Teja, sir.
Ma'am, it's regarding the tentative schedule of the program. So Torts will be done now and followed by. So the whole.
I think I would follow it with constitution. Torts, I'm trying to finish it off earlier as possible before the schedule. We are trying to club two topics. Just we have the schedule. Torts is very simple, right? I can club the topics that we are planning and quickly finish it off. Start with constitution and international law.
Okay, ma'am. So will all the topics will be completed?
Definitely. If you feel any topic is not completed, you can very well tell us and we'll be glad to have a extra class.
Okay.
Okay, all right. Anything else? Okay, happy then. Oh, Shubham is having a question. Please let me know, Shubham.
Yes, ma'am. Ma'am, I don't have a question, but I have a query. Ma'am, I don't have a background in law. So, ma'am, I want to and ask that what extra steps do I need to take so that I can be at par with the class?
Understood, understood. So today's class, you find it difficult in any areas? You're not able
No,
to follow?
no, ma'am, not that much.
Okay. So one thing, we do have Neha Jain ma'am. She was the first student actually, and she got AR 14, and she is a doctor. Okay. So I don't say that you cannot do. You can do in this. You already knew that. That's why you are here. But the
Yes,
point is, there'll be certain areas which you'll not understand since it is a new subject. So I would request you to point all these out. Take a pointer. When I'm taking class, don't note everything and don't waste time searching. I'm right there. Okay. After the class,
okay,
I'll be glad to spend 10 to 15 minutes explaining that to you.
okay, fine.
Okay. We'll do that. So that will be very helpful. If you go search and understand, I don't know whether you are in the right point. So in this class, if you have any terminologies that you don't understand, you can put forward.
Fine, fine. Thank you.
Yeah, thank you so much. So you can WhatsApp to me as well. I'll be right there replying.
Yes, ma'am. Thank you.
Thank you so much. We'll meet in the next class.